Like most in-house counsel nowadays, you have a tremendous amount on your plate. And the scope of your work is only expanding as you are pulled in various different directions. Although it sounds cliche, you're asked to wear many hats, advising on legal issues, of course, but also issues involving business, compliance, risk. And things only seem to get more complicated each year. Corporate structures, regulatory regimes, and also the degree to which your company relies on you to use your crystal ball to flag issues and manage exposure. In short, your job is to protect the company, and as a lawyer, everything you do intersects with your ethical obligations. Nowhere is this more true, perhaps, than with your duty to preserve the company's confidential information. Failing to think through how you handle emails, how you share information with your company's auditors and other third parties can lead to catastrophic results, reputational damage, but also waiver of privileges and even court sanctions or discipline by ethics authorities. No pressure, right? Let me give you a quick preview of the issues I'll be discussing today. Over the next half hour, I'm going to try to give you a few insights that you can take with you into your practice and rest a little easier that you're staying on the right side of compliance with the ethics rules while protecting your company at the same time. I'll provide some real-world examples to try to make the issues more concrete. First, we'll talk about how to define what is privileged and how to segregate what is confidential from what is not, so that you have the best chance of maintaining your company's sensitive information. Second, once you know what's protected in the first place, we'll explore strategies for avoiding waiver. Third, we'll cover some important rules and tips that you need to know regarding conflicts of interest. And after covering these issues, I want to touch briefly on a few other ethics compliance issues that you should be staying on top of as in-house counsel. So let's get started with some background about protecting confidential information and navigating conflicts. First of all, confidentiality and privilege are not the same. As lawyers, we all have the duty, sometimes called a duty inviolate, at every peril to ourselves, to protect our client's confidential information. That means anything that the client regards as sensitive and wouldn't want the lawyer disclosing. That could mean an internal business review of a product's efficacy that your company regards as sensitive information. If you're aware of it, you need to make sure there are controls in place to keep what you know protected. Attorney-client privilege is not an ethics rule, but an evidentiary rule. It's a privilege against having something admitted as evidence. It applies to a communication involving client and lawyer with legal advice as its purpose. Attorney work product is another privilege, this time against disclosure in litigation-related discovery. It applies to materials prepared in anticipation of litigation by a lawyer or others necessary to the litigation process. Now, in practice, what is confidential under the ethics rules is quite broad, but it includes anything that is attorney-client privileged or work product, so I'll focus mostly on these concepts today. Privilege issues often intersect with issues regarding conflicts of interest. I know what you're thinking. Aren't conflicts only for outside lawyers with multiple clients to worry about? No, the conflict rules apply to in-house counsel just as much. Think about conflicts this way. Your job is to manage expectations about where your loyalties lie as among various affiliates, directors, employees, and other constituents of your organizational client, some of whom may have differing interests. That's exactly what you need to be doing in order to protect privilege as well, and I'll come back to that point later on. The first area I want to focus on is how to know when something is privileged and confidential in the first place, so you can take steps to maximize confidentiality. For attorney-client privilege, because you wear many hats, you really need to understand whether communication relates to legal or business advice. It'd be easier if there was one set of universal rules, but courts apply different tests. Some look at the primary purpose of the communication, whether it's for the purpose of seeking or giving legal advice or for some other purpose. In other words, would the same communication take place in the ordinary course of business, even without any need for legal advice? Other courts will find a communication privileged if it has a dual purpose, both legal and business advice. And still other courts say the communication must be solely related to legal advice in order to be privileged. Now, the fact that courts apply different tests is critical, and the analysis is not as easy as finding out what test is applied in the jurisdiction where you're located. Remember that if push ever came to shove and your company finds itself in litigation over privilege, you aren't in control of where that litigation might be brought and what law may apply. A court may apply the law in the jurisdiction where it's located, or its choice of law analysis may lead it to apply to some other jurisdiction's law. So you need to be thinking about a least common denominator approach, that the greatest way to control risk is to ensure that communications you truly want protected meet the strictest standard. In other words, that they solely relate to legal advice. Some examples. Let's say an executive asks you to review an employee bonus plan for your thoughts. You have thoughts about the potential discriminatory effect of that plan. You also have thoughts about the financial bonuses to be given to specific employees on a merits basis. We'll put your advice about each issue into separate emails and expect that only your email containing legal advice will be protected. Same thing with respect to reviewing your company's IT systems on issues of data protection. Yes, you have advice to give on global data protection laws. Just remember that for any advice you give that isn't solely about legal compliance, for example, whether the IT system is a cost-effective one or thoughts on certain IT personnel, put those in a separate email. For financial institutions analyzing a borrower's compliance with various covenants, then a purely economic analysis as to a covenant over a financial metric is much less likely to be protected than an analysis of whether the borrower's financial condition meets the legal standard for a material adverse effect. The lesson here is to segregate legal from business advice and do so consistently. You might be thinking it's often very difficult to segregate business and legal issues because they often overlap. And you're right. But think about it from the perspective of a court down the road trying to weigh what the primary purpose of your email is, or even whether there's any business purpose to the email at all, in which case your email might be ruled non-privileged in its entirety. So if there's an aspect of your email that's particularly sensitive legal advice and you want to keep it confidential, segregate that out. When talking about attorney work product, remember that if you feel that you meet the standard, that the material is prepared in anticipation of litigation, then you need to act accordingly. My tip for you is this: if you truly foresee litigation to the point that you're creating written materials, analyzing possible litigation issues, then you also need to set up a litigation hold on documents in order to preserve evidence for that litigation. When it comes to work product, courts scrutinize your actions for consistency. So a court may decide if you haven't preserved documents for litigation, that work product protection shouldn't apply. Or your company could be sanctioned for failing to preserve evidence from the time documents start getting labeled as attorney work product. And speaking of labels, use them judiciously. Don't just label everything that comes across your desk or every email you send as privileged. Here's a situation I see all the time. The bankers at a financial institution retain an outside vendor to analyze a borrower's financial performance. They want to make sure the vendor's work is privileged, so they tell the vendor, label all emails and reports as privileged and confidential and attorney work product. They also tell the vendor, for good measure, to copy you as in-house counsel on all correspondence. Well, their intentions may be in the right place, but none of those steps will make any difference without much more attention being given to the issue of privilege. Courts can be quick to find that labels are used as mere window dressing. Rather, here's what you need to do. Get involved early. This means you need to make sure the bankers and other employees are trained on issues of privilege so they know to bring you in. Do an analysis to determine if the vendor's work will meet the standard for the work product doctrine in the first place. Is it truly being created in anticipation of litigation? If you believe it meets the standard, then you or outside counsel should retain the vendor and oversee its work. By doing this, you're demonstrating that the vendor's work is under the direction of counsel to assist with legal work. Then make sure that the vendor labels only those analyses that are truly work product as such. By the same token, once you've segregated privileged materials from business ones and used labels accordingly, remember to continue to maintain truly privileged materials separately. Share them only on a need-to-know basis. In other words, with all of these actions, you're demonstrating to a court that you acted consistently with an expectation of confidentiality as to the most sensitive legal documents you have. Once you know you have something privileged and are taking steps to treat it confidentially, then you need to make sure you're protecting the materials against a waiver. Knowing how and when privileged material can be shared with third parties is tricky business. Here are some general rules. If it's an attorney-client privileged communication, sharing it with any third party, anyone besides your client, is presumptively a waiver. That's because the evidence rule protects only the communication between lawyer and client. Bringing a third party into the mix is regarded as inconsistent with an expectation of confidentiality in those communications, unless that third party is considered necessary to the delivery of legal advice, such as a forensic accountant retained under the direction of an attorney to help uncover facts to help the lawyer provide legal services. If it's attorney work product, there's a bit more leeway. That privilege protects against adversaries getting the benefit of an attorney's litigation prep work. For that reason, sharing with a third party isn't necessarily a waiver. Instead, it will result in a presumptive waiver only if the third party is an adversary or a conduit to an adversary. How does that work in practice? Well, let's say you have prepared a legal exposure analysis as to a particular financial product created by the bank that you work for. There's a wholly owned subsidiary of the bank that makes use of the same product, and the analysis would apply equally to that subsidiary. There's no reason to believe that the subsidiary is an adversary, nor is it a conduit to adversaries. In other words, there's no reason to believe the subsidiary will turn around and share it with a potential claimant or regulator. Therefore, it's unlikely that sharing it will result in waiver. On the other hand, let's say you work for a private equity sponsor involved in an additional investment in one of its portfolio companies, and you wish to share an analysis of certain litigation risk issues related to that transaction. Because there is arm's length transactional adversity, many courts will find that sharing the analysis in that context results in waiver. Now, there's an exception to the waiver rules where the parties share a common interest. I find that the notion of a common interest doctrine is bandied about, relied upon way too frequently without a sufficient understanding of its limits. First, there must be a sufficiently legal interest shared between the parties, generally meaning there is actual legal exposure to each party, such that there is a real need for each party to rely upon the material shared, often from a litigation perspective. Second, it's not enough for the parties to share a mere financial interest. Some examples. Let's say you work for a financial institution that serves as administrative agent in a syndicated loan. The agent's deal team wants to share the analysis of the borrower's covenant compliance with the other lenders. If that involves the banks all merely analyzing and protecting their financial interest in the loan, that won't be a sufficient common interest. On the other hand, an agent should be able to share with the other lenders an analysis of the legal implications of refusing a borrower's funding request, including the potential for lender liability claims. The lenders there have a common legal interest because they all may face legal exposure in the context of a prospective litigation. Or let's say you work for a privately owned company that is the defendant in a material litigation. You would like to send an analysis of the litigation issues and the company's damages exposure to the company's major investors. Most likely, unless those investors face their own exposure as potential co-defendants in the litigation, a court would find that the investor's interest in reviewing the analysis is merely a financial one. Keep in mind also that some courts refuse to find a sufficient common interest at all between parties to a transaction, unless there truly is a prospect of litigation. Because of that, then, under the least common denominator approach, you and your company need to understand the risks of sharing in the transactional context. For those courts that do recognize a common interest in a transactional setting, the two sides can't merely be in preliminary talks of a possible transaction. The parties must clear some hurdle so that the prospect of closing the transaction becomes concrete. So, for example, in the merger context, courts generally do not find a common interest between a seller and a mere bidder. But where there's a winning bidder that signs an agreement, generally on an exclusive basis, At that point, courts often hold that the parties have a common interest in sharing work product so they each can understand material legal risks in the transaction, such as litigation assessments and compliance issues. Prior to that point, the interest of a bidder in possibly entering into a transaction is often regarded merely as a financial one. Another example is in sharing work product with the company's outside auditors. For example, regarding litigation loss contingencies or tax accruals. Again, courts are split on this, with some courts holding that an outside auditor is akin to an adversary or a conduit to adversaries. Those courts reason that public company auditors are regulated and may have disclosure obligations regarding their audit work, and also that auditors may need to take action in connection with the audit that are not aligned with the company's interests. Most courts, however, recognize that companies and their auditors share a common interest in appropriate public disclosures that comply with both legal and accounting issues. Here's a tip then when considering the common interest doctrine. Although a court may recognize a common interest with or without a written agreement, you can improve your company's position before a court by documenting the parties' common interest. Include details about the exact legal interest the parties share, and in particular, the litigation exposure they each share, as well as the steps they agree to take to maintain the confidentiality of the shared materials. Because there's so much uncertainty in the law on this issue, this can help educate a court about the proper reasons for sharing the materials and nudge it along to the right conclusion. You also may be aware of a notion called selective waiver, generally choosing to share a document with one adverse party, for example, a government regulator, in order to show cooperation, while continuing to maintain privilege as to others. You should know that while some courts recognize a party's ability to waive privilege selectively in this way, the vast majority of courts do not. As these courts have said, you can't share a document with an adversary, an act inconsistent with confidentiality, and then turn around and assert confidentiality as to other parties. Using the least common denominator approach again, you need to make sure that your company understands the risks here. I never advise that it's safe to rely on the selective waiver doctrine. As I said before, the rules regarding privilege and confidentiality intersect with the rules regarding conflicts of interest. And you do in fact need to be thinking about conflict issues even as an in-house lawyer. Picture this scenario. You're hired to work as an in-house lawyer for a pharmaceutical company. You and the company check conflicts when arriving, but nothing you had done before involved any interaction with your new company. After you arrive, your company acquires a patent and then retains outside counsel to bring an infringement suit against your former employer, where many years earlier you had evaluated the same patent. Of course, there is nothing even to be flagged at the time you were hired because your new company didn't even own the patent at issue then. Nevertheless, this is still a conflict for you because the infringement case is substantially related to the work you did for your former employer. And it's not just a conflict for you, it's a conflict that, if not cleared when it arises, many courts would impute to the entire in-house legal department. What does clearance look like? It generally involves reaching out to your former employer, letting it know you'll be screened from the matter at your new company, and asking for and obtaining consent to proceed on that basis. What if the former employer says no? Well, if your company sets up a wall on a timely basis, effectively screening you off from the matter, some courts will then honor that and hold that your confidential information should not taint others at your company and the outside lawyers handling the matter. Other courts, however, do not recognize the use of screens at all without getting the actual consent of the former client. The point here is that at a minimum, there needs to be a process in place to identify these conflicts, and if they arise, you need to think through the issues immediately and carefully. On top of that, conflicts don't just arise for in-house lawyers based on work they did for prior clients. They can also arise from work performed within the organization. Just like when analyzing privilege issues, the overarching principles are to know who your client is, as compared to third parties involved in some way, and also to be clear where your loyalties lie. When your client is an organization, your loyalty runs to that organization itself. Of course, an organization acts through its agents, so as a general matter, in-house counsel take direction from management. But if you ever came to believe that management's actions were against the best interests of the organization, your obligation is to take your concern up the ladder within the organization to higher and higher levels of management, or to the board if necessary. How does that work in practice? Let's say your company is in a financially distressed situation and asks you to analyze a transaction, which you conclude would be a fraudulent transfer. Management may be asking you to recognize that the company desperately needs to look at creative solutions to its financial distress, but you believe it would not be in the company's best interest to engage in the transaction. The transaction would be subject to clawback and may open up the company to further losses. If management doesn't take your suggestion to forego the transaction, your job is to take the issue to the highest levels of management, or to the board if needed. If the board doesn't listen, you may need to consider resigning. In short, the ethics rules emphasize that your job is to protect the greater organization itself, not just the individuals with which you work every day. Hopefully, there's never a conflict between the employee and the organization, but they do arise. For example, perhaps there's an accounting discrepancy at the company where you work, and you're involved in conducting an internal investigation that includes interviewing the CFO. The CFO needs to be given what are called upjohn warnings, namely that you represent the company, not the CFO, and that as a result, the privilege that applies to the discussions you're about to have belongs to the company, not to the individual. And these warnings matter because if the individual is led to believe reasonably that you're acting in his or her interest and that you'll keep your communications confidential, a court is likely to find an attorney-client relationship with that individual. And the ramifications of that are significant. For one, the privilege will belong just as much to the individual and not just to the company. If your company later wants to report the results of its internal investigation to a regulator, the individual may be able to prevent privileged discussions that you had with him or her from being shared. As an in-house lawyer for an organization, you also may be called upon frequently to give advice to subsidiaries and affiliates of your employer. The principles here are similar. The first thing you should do is conduct an alter ego type analysis. Is it a wholly owned subsidiary without its own board or its own in-house legal department? Does it report up to and act solely for the benefit of the parent? If so, then the scope of your client organization more likely will include the subsidiary. If it operates independently, then it's unlikely to be considered your client just because you're an in-house counsel for the parent. One general rule of thumb is to consider whether your communications with the subsidiary or affiliate would be considered privileged. In addition to the alter ego questions we just discussed, think about whether the interests of the parent and the subsidiary or affiliate are aligned. Are they acting at arm's length across the table from one another? Or is the subsidiary insolvent or potentially insolvent? If it is, it may owe duties to its creditors and others above any obligations it may have to the parent. And because of that, it will be less likely that a court would consider the subsidiary part of your client organization, just as it would be less likely to protect as privileged your communications with the subsidiary. Overall, remember to step back before putting yourself in a position of either giving legal advice or receiving confidential information from someone or some entity in your organization. Assess whether there are conflicting interests or even potentially conflicting interests. Be transparent about who you represent. Taking these steps requires some time, but failing to take them can have serious consequences. There are a few other issues I want to touch upon just briefly. One is cybersecurity. Hardly a day goes by, it seems, without hearing about a corporate cyber attack, data breach, or potential data breach. As in-house counsel, you need to be preparing long before anything like this happens to your company. And if it does, you need to know how to respond. First of all, this is not just a risk issue, it's also very much a legal ethics issue. Many jurisdictions now have ethics rules requiring attorneys to have a reasonable understanding of technology, including the manner in which electronic data related to clients are stored, and to act reasonably to safeguard confidential client information, including against inadvertent disclosure to third parties. These principles apply to in-house counsel as much as to outside law firms. So as in-house counsel, you should be involved before any data breach to assess the effectiveness of the data storage methods used by your company. Specifically, you need to understand your company's electronic communication and data storage systems, and how those systems might be accessed by third parties in order to manage risks by adopting appropriate safeguards. You should conduct diligence on your data vendors, analyze the risks of a data breach, review potential insurance coverage for cybersecurity, and make sure necessary employees are trained on data protection. And you need to review your company's safeguards and update its procedures continually in response to new developments. If you become aware of a breach or a potential breach, of course, immediately put into effect your company's incident response plan. Also, investigate the breach in order to take swift and reasonable action to understand its nature and safeguard your company's data and systems against similar breaches in the future. It's entirely reasonable for you to work with appropriate IT personnel and vendors on all these efforts, but ethics opinions make clear that it's not enough to satisfy your duty of technological competence as a lawyer simply to stand by just because other professionals are involved in these issues. I also want to touch briefly upon in-house lawyers' compensation structures. Because of the fiduciary relationship between lawyer and client, the ethics rules prohibit business transactions with a client without following some guidelines. For the in-house lawyer, we're generally talking about compensation arrangements that involve stock or stock option grants or awards of equity. For these structures, the client needs to provide an acknowledgement that it's had the opportunity to discuss the arrangement with separate counsel, that the terms are fair and reasonable, and that the client consents to the arrangement. And the client needs to do all this in writing. Now, the client also needs to consent in writing to any potential conflict that the compensation structure may create for the lawyer. For example, if the in-house lawyer is awarded equity in a particular subsidiary that the lawyer helps to establish, the lawyer could be viewed as personally interested in taking steps that will shore up the value of that subsidiary, even if those are not the most advantageous steps for the parent. Making sure that all of these points are covered in a written employment agreement up front or an agreement in connection with the specific award of equity or stock is critical. Courts and bar associations have concluded that attorney compensation structures that do not comply with these ethics rules are voidable. Finally, a quick note on unauthorized practice of law. Every state has ethics rules or even criminal statutes prohibiting the practice of law in that jurisdiction by anyone who's not licensed to practice law there. In many ways, these rules are out of touch with today's legal profession, where attorneys regularly perform work that crosses over state lines or work for clients with a presence in many jurisdictions. While there have been some efforts to modernize these rules, they haven't kept up with today's multi-jurisdictional legal careers. This is particularly so for in-house counsel in large, multi-jurisdictional companies who often hire lawyers without particular regard for where they happen to be admitted to the bar. What happens when an attorney is hired as in-house counsel and will work in a jurisdiction where the attorney is not admitted? Unfortunately, courts and state bar disciplinary authorities often will regard that attorney's work as unauthorized if the attorney fails to gain admission in a timely manner in the new jurisdiction. And that's true even if the attorney professes to advise the company only on transactional issues unrelated to the law of any particular state, or to advise only on matters of federal law, or to advise only on the law of the attorney's home jurisdiction. Unfortunately, many jurisdictions have established in-house counsel registration programs where in-house counsel can gain protected status. You need to demonstrate that you're admitted and in good standing in another jurisdiction, potentially even one outside the U.S., and this often means staying up to date on your continuing legal education requirements. You also must attest that you will represent only the company and you'll limit what you do. For example, not appear in court or advise on issues of state law. But you must register for the program, and often you need to do so within a short period of time after starting work as in-house counsel. Otherwise, you might need to get admitted to the bar in that jurisdiction. Let me leave you with a few thoughts to close. I've provided some general rules of the road and tips regarding privilege, confidentiality, waiver, and conflicts. But it should be clear by now, ethics principles and issues of privilege and waiver are not always hard and fast rules. They're more like guidelines, and particularly fact-intensive ones at that. And there are exceptions on top of exceptions. For in-house counsel for international companies, for example, You should know that the rules regarding privilege and conflicts of interest in Europe and elsewhere can be quite different than those in the US. Again, while the issues can be flagged, they may require some additional discussion. I'd like to say that the rules are all common sense, but they more frequently are quite nuanced, and they vary from court to court. So remember the least common denominator approach. The safest course is to comply with the strictest standard. The less you do so, the more risk you're taking on. The good news is that half the battle is preparing in advance so that you truly can flag the issues as they arise. To that end, we've provided you with a bit of a cheat sheet that was created to go along with this presentation. By maintaining an awareness of these issues, you'll be in position to train other employees and even stay on top of outside counsel to make sure you're doing your best to protect your company's most sensitive information, all while staying on top of the ethics rules yourself.
It's Murphy's Law that things will go wrong in any given situation if you give them a chance. A corollary to that rule is, if everything seems to be going well, you've obviously overlooked something. Or, as a pundit has said in another way, it's impossible to make anything foolproof because fools are so ingenious. When representing a multi-entity enterprise and its directors and officers, there are more opportunities for things to go wrong than with a corporation whose clients are all contained within one entity and there aren't multiple affiliates. If you keep a few principles in mind, you'll decrease the chance that there will be a mishap. So what are the topics I'm going to talk about today? And sort of a list of items for you to consider. First, know who your client is. Second, make sure that those with whom you're communicating understand who your client is. Third, don't assume that conflicts cannot exist within a corporate family. Fourth, be particularly wary if a corporate family member is in financial distress or has a minority ownership. Fifth, even limiting disclosure of privileged information to those within the corporate family can still result in the loss of privilege. Sixth, remember that your client today may be an adverse party tomorrow. So let's talk a little bit about the principles. Topic number one, who is the client? Many corporations have counsel at the corporate parent level. Rarely does inside counsel hold a position at more than one corporate family member. There is no rule that simply because you represent one corporate family member, you automatically represent them all. As inside counsel, you may represent a corporate family member that is not your employer. Affiliates may reimburse the corporation that actually employs the in-house counsel for costs. But the legal department may not be a profit center. Inside counsel may represent more than one corporate family member simultaneously. Usually, inside counsel will not represent more than one corporate family member on the same matter. The representation of one corporate family member on an issue does not make that corporate family member a client for all issues. If counsel is advising a business person employed by or serving as a director of more than one corporate family member, that does not make all the corporate family members for which that person works clients. Rule of Professional Conduct 1.13f requires that counsel explain who the attorney is representing if, when dealing with the constituent, the lawyer knows or should know that the interests of the organization are adverse to those of the constituent. Now, you should note that all 50 states and Washington, D.C. have adopted the ABA model rules format, although none has actually adopted the model rules exactly. California was the last U.S. jurisdiction to do so, effective November 1, 2018. This rule that we were just talking about is the same in California and New York, although in New York it's numbered slightly differently. It's Rule 1.13a. So, topic number two. When can there be a conflict within the corporate family? Now, when a company is solvent, the duties of the directors and employees are to the owner. That is, in the case of a subsidiary, to the parent company. In the case of solvent, wholly owned subsidiaries, representing a parent company and a subsidiary will not generally create a conflict. It does not matter that the actions as to which advice is being provided may harm the prospects of the subsidiary. When a family member is insolvent or will become insolvent as a result of a transaction under consideration, its directors and employees owe a duty not just to the owner, but all constituents, in particular creditors. Under those circumstances, it may well be a conflict to represent the company and its affiliates because the interests of the parent company and the creditors may well not be in alignment. Now, an example of this is the Caesars restructuring. In that case, a single law firm represented the operating subsidiary and the parent company. The transactions involved transferring significant assets from the operating company to the parent company. The problem was, in retrospect, it appeared as if the transfers either made the operating company insolvent or the operating company already was insolvent. An examiner who came in and looked at these facts afterwards determined that the law firm had a conflict of interest in representing both sides of that transaction because, again, the interest of the operating company and the parent company in transferring these assets out of what appeared to be an insolvent company were not aligned. So, what should inside counsel do if you cannot tell if the company is insolvent? Either assume there is a conflict or obtain expert advice on solvency. By the way, the concept of being in the zone of insolvency is no longer considered to be relevant. You actually have to be insolvent to have this duty switch. So, what if there are minority owners of a subsidiary? How will that create a conflict or of interest? If an action will harm the company, even though the action will be good for the majority owner, in-house counsel will have a conflict, representing both the company and parent as to that issue. Here's an example. There is an alleged bribery of a foreign government official, and it's unclear whether the responsible party is the parent or subsidiary. If the subsidiary has minority owners, there may be a benefit if the wrongdoing is found to be at the parent level. If so, it would represent a conflict to represent both the parent and the subsidiary at the same time. So, what are the consequences of the inside counsel having a conflict of interest that's not addressed? If counsel has a conflict, the failure to receive unconflicted legal advice could result in the loss of protection of the business judgment rule. And the consequence of that is the whole fairness test would then have to be satisfied. There's also a potential privilege consequences that I'll discuss shortly. So let's move on to topic number 3. How do you make it clear who you're representing? Now, a writing is not required, but joint representation can be found to exist where a lawyer gives advice to two corporate family members who have the same or similar interests in an issue. Joint representation can be terminated. This can happen by implication if a conflict arises between the jointly represented clients. It's best practice to make clear in writing, like an email, who the client is, and if a joint representation is ending, confirm that in writing too. Now, I recognize in each and every instance you're not going to put something in writing, but where the advice involves a significant issue, it's still a good idea to do so. If there's a conflict, the conflict can be addressed by retaining outside counsel to represent the subsidiary. Of course, inside counsel for the company should not review the advice given to the subsidiary by the outside counsel. If one member of the legal department has a conflict, all do because under Rule of Professional Conduct 1.10, which is the imputation rules, conflicts that one lawyer has are imputed to all lawyers in the law firm. Now, for these purposes, law firm includes law department as well. The rules explicitly so state. Note that before November 1, 2018, California had no rule on imputation of conflicts. There was significant case law on the subject, however, which made clear that this imputation rule still applied. But now it does, and so does New York. So you don't have to look to the case law in California anymore. Now let's go to topic number 4, basic privilege issues. So I'm going to cite to you a classic definition, Wigmore on evidence. It has an 8-part definition of the attorney-client privilege. And that definition is, 1, where legal advice of any kind is sought. 2, from a legal professional advisor in his or her capacity as such. 3, the communication relating to that purpose. 4, made in confidence. 5, by the client. 6, are at the client's instance permanently protected. 7, from disclosure by the client or by the legal advisor. And 8, except the protection can be waived. Now, there's a similar definition in Restatement Third of Law Governing Lawyers. It's in section 118. It's also frequently cited. So, privilege is intended to allow a client to freely speak to his or her attorney in order to obtain legal advice. The privilege does not apply to all communications between corporate counsel and the client. Before 1981, only the communications between counsel and corporate employees within the control group, and that is those who made management decisions, were potentially protected by the privilege. The Supreme Court in Upjohn versus United States adopted what's been called as the functionality or the subject matter test. Under that test, the privilege extends to all employees having relevant information required by the lawyer to provide the requested legal advice, as well as those who can act on the advice. So it's a much larger group than just the control group. Be careful, because while the Upjohn test is accepted in federal courts when federal common law applies, to the extent state law applies, some states still use the control group test. So the attorney work product doctrine applies to protect information where another privilege does not apply. So as a technical matter, if another privilege exists to protect the information, you don't look to the work product doctrine. The federal work product doctrine is defined in Federal Rule of Civil Procedure 26b-3 and protects materials prepared in anticipation of litigation by or for a party. It protects materials prepared by non-attorneys. But, and this is a big but, disclosure may be compelled if there is a substantial need for the materials and the information cannot otherwise be obtained without substantial hardship. The exception, however, does not apply to an attorney's thought processes. Those thought processes receive absolute protection. Now, there's a difference of opinion as to whether or not a reason or the reasons for the preparation of the materials is contemplated litigation. For example, Kellogg, Brown & Root, Inc., a 2014 D.C. Circuit opinion, concluded that litigation preparation need be a purpose. It need not be the only purpose. Now, why do we have work product protection? Work product protection is to provide a zone of privacy in order to allow a party to prepare for litigation. It's also based on fairness, because it would not be fair to allow one party to take advantage of the opposing party's preparations. Sharing attorney-client privileged information with a third party usually will result in a waiver of the privilege, unless some special exception applies. Work product may be shared without a loss of the protection so long as the third party does not have an interest adverse to the interest of the sharing party with respect to the information being shared. When different attorneys represent parties and those parties have the same or a very similar interest, those attorneys may share with each other privileged information without the loss of privilege pursuant to a joint interest agreement. Such agreements may be oral. Note that some courts require the interests to be identical, but most do not. Also note that a number of courts only allow counsel to share information pursuant to the arrangement, not the parties themselves. Finally, note that many jurisdictions like New York and Texas do not recognize the privilege outside the context of litigation. Thus, it doesn't apply in a transactional setting. Delaware by statute recognizes that there may be a joint interest protection afforded in the context of transactions. So, joint representation is a different concept, where an attorney represents more than one client in the same matter. In this case, the interests of the clients need to be materially the same. Then, the attorney may share the same advice with those clients and the privilege will not be lost. One of the complications is that an attorney has a fiduciary duty to all the jointly represented clients, and so must share the material information about the joint representation with all the clients. It's unclear if this obligation can successfully be waived. With a joint representation, the privilege can only be waived with regard to third parties if all the joint represented parties agree. However, if there's a dispute between the jointly represented parties, neither of the parties may assert privilege against the other as to the joint representation advice, and all are entitled to have and use the joint representation communications in a dispute between the jointly represented parties. But note that the Garner fiduciary exception to the attorney-client privilege, which is from the case of Garner versus Wolfenbacher, a Fifth Circuit decision, may come into play where the client is insolvent because of fiduciary duties to all constituents, including third parties. So in that case, creditors may seek access to privileged communications belonging to the insolvent company. I might add that this Garner exception is one that is confusing to practitioners as well as to courts. Now, sharing privileged information with directors or employees of a corporate client can result in the loss of the privilege if the directors or employees with whom the information is shared do not need to know the information or have an interest that is adverse to the corporation with respect to the advice. Thus, sharing a report generated by counsel for a special committee with the entire board, including board members who are the subject of the investigation, can result in the loss of the privilege. Likewise, privileged information can be shared within the corporate family of companies if the companies receiving the advice need to know the information and have the same interest as to the advice. Under such circumstances, care should be taken so that the companies receiving the advice are not deemed to be joint clients of the attorney. Note that the privilege also may be lost if it's not clear that the information being shared is attorney advice. In other words, information shared appears to be a business directive, there will be no privilege. So let me give you an example. Oftentimes with companies that are based overseas, the U.S. subsidiaries don't actually have decision-making power over significant issues. So while the attorney may report to the client in the United States, the executives at the subsidiary will report to their bosses overseas. If those communications look like a business communication and don't make clear that what the U.S. subsidiary is doing is passing on business advice, the communication with the parent company, which actually contains attorney-client advice, may not be subject to the attorney-client privilege. Now, I'd like to move on to a key case. It's a Third Circuit opinion. It's called In Re Teleglobe Communications. It's from 2007. It's quite a lengthy opinion. It's close to 100 pages in length. It's, however, a very significant opinion and one that I recommend that all practitioners read at some point. So here are the facts of that case. Bell Canada Enterprises, which I'll call BCE, which was the largest telephone company in Canada, owned a minority stake, 23%, in another company called Teleglobe Inc. I'll refer to that as just Teleglobe. Teleglobe was developing a fiber optic network called Globe System. BCE decided to buy out the other minority shareholders, taking over complete control of Teleglobe and its subsidiaries, and then caused Teleglobe and its subsidiaries to borrow $2.4 billion, which was to build out this fiber optic network. BCE, when that money was run through, gave Teleglobe an additional $850 million in the form of an equity infusion. So BCE began to reassess the likelihood that Globe System would be a success and considered various alternatives for dealing with it. This was called Project X. BCE ultimately decided to stop funding Globe Systems. which meant that Teleglobe and its subsidiaries could not pay their debt. And it and its subsidiaries filed for bankruptcy. Now, of course, Teleglobe didn't have the right to receive funding from its parent company, and it was not an unreasonable decision for BCE to decide that they were going to cut off the bleeding. If this fiber optic systems wasn't going to work, there was no reason to continue to sink money into the project. However, Teleglobe's subsidiaries sued BCE for breach of contract, breach of fiduciary duties, and estoppel, and negligent fraudulent misrepresentations. Teleglobe's subsidiaries sought BCE's privileged information developed at the time that BCE owned Teleglobe. The issue before the Third Circuit was whether to uphold the district court's decision that BCE had to turn over privileged information that its inside counsel had concerning Project X. The Third Circuit reversed the district court decision and sent the case back to the district court to make certain factual determinations that the district court had not made. Primarily, whether any attorneys had jointly represented BCE and Teleglobe subsidiaries on a matter of common interest. The district court and parties had focused on the joint interest doctrine. The Third Circuit made clear that this was an error. The doctrine only applies if the corporate family members have different counsel, and the counsel is sharing the advice each has given. Here, the issue was whether the advice of one set of lawyers, inside counsel or BCE, was privileged. The court explained that the reason that the shared information was protected was because of the joint representation doctrine. Inside counsel for BCE arguably was representing BCE and Teleglobe. BCE was not contending that Teleglobe subsidiaries were jointly represented by BCE's inside counsel. Thus, the subsidiaries were only third parties and only entitled to see the joint representation privileged information if both BCE and Teleglobe agreed to waive the privilege. But BCE refused to waive. Admittedly, in-house counsel for BCE had represented Teleglobe on some matters, and the subsidiaries on some matters as well. That did not mean that BCE was representing Teleglobe's subsidiaries as to Project X. The Teleglobe subsidiaries were only entitled to have disclosed to them documents that BCE had that concerned the joint representation. Teleglobe's subsidiaries said that BCE waived any right to claim privilege as a result of statements BCE's lawyers made in bankruptcy and before the district court. That is, they had said that they would produce joint representation documents. The Court of Appeals found that there was no waiver, but BCE should have been more thoughtful about the positions it took on privilege before making concessions or arguments. Advice of outside counsel to BCE was also channeled through BCE's inside counsel, and a waiver was claimed by Teleglobe subsidiaries because BCE's inside counsel purportedly had a conflict in representing both BCE and Teleglobe and its subsidiaries if Teleglobe and its subsidiaries were insolvent. The court, citing the Eureka case, found that the privilege was not lost merely because counsel had violated its ethical obligations and represented multiple parties, although it had a conflict. Here are some takeaways. First, consider who you're representing and whether there are current or potential future conflicts that could arise between the corporate family member that employs you and others that you are being asked to advise. Second, if a corporate family member is going to be separated from the corporate family, either because it will be sold or it will file for bankruptcy and an independent trustee will take over the management of the family member, consider carefully whether a joint representation actually makes sense. If there's a conflict, retain outside counsel to represent the subsidiary, and don't review the advice that outside counsel gives the subsidiary. Fourth, be sure to understand who you're representing and make sure that your advice is not shared with other corporate family members that do not need your advice or have an interest that does or may diverge from the entity that employs you. Fifth, in potentially difficult situations, consider documenting in some way who you're going to represent and who should receive the advice that you're going to give. Also, if a joint representation has to be terminated, document that too. And sixth, do not forget work product claims, because work product protection is not lost by sharing protected materials with a corporate affiliate, even where there is no joint representation, so long as the affiliate's interests are not adverse at the time of the sharing. I hope you found the presentation to be useful, and thank you for listening.